Tanya Chutkan challenges Jasmine in court, but Jasmine flips the whole case. What happened in courtroom 12B wasn't just another legal skirmish. It was an eruption that sent shockwaves far beyond the marble walls of Washington's federal courthouse. On a day that began like so many before it, Judge Tanya Chutkan looked every bit the master of her domain, stern, brilliant, and known for shutting down grandstanding with a single, icy glance. Journalists pressed their faces against rain-streaked windows, legal experts whispered from the gallery, and the case on the docket had already been labeled the most important constitutional showdown of the decade. Yet in less than an hour, order would be overturned, reputations would be made, and America's faith in the law would be both shaken and restored, all because of a single, riveting move by Congresswoman Jasmine Crockett. It started as a panel battle between two of the Capitol's toughest minds. Crockett, a rising Texas star with razor-sharp legal instincts and a reputation for turning courtroom drama into policy change, was summoned not as a defendant, but as a key witness. Her role: explain to Judge Chutkan and to the nation what lawmakers really meant when they drafted the rules that now stood threatened by a sweeping executive order. The stakes? Nothing less than the fate of worker protections, environmental laws, and the strength of the constitutional firewall between federal and state power. Inside, tension thickened the air. Practiced lawyers fidgeted with notes, reporters tapped headlines into their phones, and onlookers adjusted ties or chewed knuckles in the gallery. This was no textbook debate. It was a powder keg of politics, power, and precedent. Judge Chutkan, ever the disciplinarian, was not about to let her courtroom become a stage for theatrics, especially from a politician. Crockett, however, wasn't here to pose on his tour. Behind her calm demeanor was a civil rights legend in the making, famous in legal circles for thriving when the odds were stacked and the clock was ticking. And then it happened. With the nation's legal establishment looking on, Chutkan tried to dismiss Crockett's testimony before it left the runway. Her move was as subtle as it was monumental. Given the clear legal precedent we've heard today, I'm not sure your testimony is necessary. The law seems quite clear on this matter. Lawyers in the gallery held their breath, realizing this was no ordinary cross-examination. The message was clear. Crockett, the congresswoman and civil rights attorney, had been cornered. She could have yielded. She could have played her part, muttering a protest and sitting down, as so many outmaneuvered witnesses had before her. But not Jasmine Crockett. In a split-second decision that would become the stuff of legal legend, she reached for her briefcase, eyes blazing with equal parts fire and focus. "Your Honor, I do have something new, something that I believe will fundamentally change how this court views this case." She set a thick folder on the lectern, a move so understated, yet so loaded with promise, that the entire room froze. What followed erased every prior assumption about who controls the narrative in a federal courtroom. Crockett, using overlooked congressional archives, personal correspondence from the era, and even a buried DOJ memo, produced evidence so explosive that Chutkan's jaw literally dropped. Cameras weren't allowed, yet the moment went instantly viral. Radio broadcasters stumbled over their words, and within hours, legal Twitter exploded with play-by-play breakdowns. This wasn't just a tactical win, it was an upheaval. As transcripts made the rounds, memes and hashtags sprang up, #Crockett Constitution, #Courtroom 12B, and law professors across the country rewrote TAO. Air lesson plans overnight. Journalists declared it a masterclass. Social media users said it made them believe in the system again. And right then, in the stillness after the storm, one thing was clear. Jasmine Crockett hadn't just changed a courtroom, she'd changed the conversation about justice in America. Stay tuned to see exactly how this jaw-dropping reversal unfolded and why it matters for every single person who believes the law can still be a tool of truth. The morning sun glinted off the marble columns of Washington, D.C.'s federal courthouse, but inside, the atmosphere was heavy, almost electric, like the uneasy charge before a storm erupts. CNN trucks idled along the curb, cameras perched atop tripods, reporters rehearsing live shots about a constitutional case that already had the nation on edge. The sidewalk thronged with protesters holding makeshift signs, some warning about federal tyranny, others rallying around unity through federal leadership. No matter which side they stood on, everyone sensed they were about to witness history, not just another headline, but a seismic shift in how power would be wielded in America. Security at the courthouse entrance rivaled that for national dignitaries. Step inside, and marble gave way to a flurry of hushed conversation in the echoing foyer. Lawyers in sharp suits shuffled through their briefs. Law students jockeyed for a spot in the public gallery, clutching dog-eared copies of the Constitution. Even a group of former legislators, white-haired and stooped, waited in line, hungry to hear the arguments that would soon determine the scope of federal power for decades to come. But most eyes weren't on the government team, formidable as they were. They were on courtroom 12B, where a battle of nerves was about to unfold between two legal titans, Judge Tanya Chutkan, the iron-willed federal jurist, and Congresswoman Jasmine Crockett, Texas's fiery new face of constitutional law. The judge's reputation as a stickler for order and her no-nonsense attitude, he had made seasoned attorneys break out in a sweat. No lawyer went before Chutkan unprepared, and those who tried to grandstand or deflect got cut down mid-sentence. Reporters whispered that she could freeze a kettle with a glance. Meanwhile, Jasmine Crockett, both admired and underestimated, waited quietly in the wings. She was a force, a civil rights attorney turned legislator with a reputation for dismantling political spin and translating complicated legal arguments into everyday language. Her recent rise in Congress was as much about her brain as her boldness. She'd survived bare-knuckle campaigns in Texas and brought with her a trial lawyer's hunger to win every fight that mattered. As she thumbed through her ever-thickening folders, her eyes revealed no fear, only calculation and purpose. The case at hand, centered on Executive Order 40823, had split the country. The directive claimed to serve national economic security, but its critics saw it as a constitutional sledgehammer, a mandate that would allow federal agencies to overrule state laws with a single signature. Environmental regulations, worker protections, and decades of carefully negotiated civil rights advancements all risked being swept away. Opposition was fierce and unique, with Republican governors, progressive activists, and business coalitions forging rare alliances, all terrified that the country stood on the edge of a legal precipice. Inside the courtroom, every seat was filled. Law professors, advocacy group spies, former Supreme Court clerks, and a smattering of nervous-looking DOJ aides. At the front, Judge Chutkan pored over her notes, betraying nothing to the restless room. The air was tense with anticipation, every creak from a wooden bench as loud as a drumbeat. When the judge finally entered, the room snapped into silence. 1,000 eyes bore down, not just on the case, but on the spectacle they knew was coming. Would Crockett's testimony be just another formality, swallowed by precedent and dismissed by a steely judge? Or would she, against all odds, break through the wall of tradition with something truly historic? In that suspended moment, D.C. held its breath. Change, everyone realized, was about to arrive, whether through the force of law or by the cunning of one determined woman. And outside, in living rooms and classrooms across the country, Americans tuned in, sensing that what happened in courtroom 12B wouldn't stay there for long. On opposing sides of courtroom 12B sat two forces whose presence alone raised the stakes. Judge Tanya Chutkan presided in her signature fashion, spine straight, eyes sharp, her gavel less a symbol than a warning. Once appointed to the bench during the Obama years, Chutkan was now infamous in legal circles for her unwavering commitment to law and order. Her courtroom had no space for dramatics or distraction. Even the most seasoned attorneys prepared for her with a kind of reverence tinged with fear. Lawyers whispered about her legendary memory for case law, her knack for dissecting even the most complex arguments, and her reputation for not suffering fools or grandstanders gladly. She was not just fair, she was relentless. Her philosophy was simple: the law comes first, politics a distant second. Her colleagues admired the way she carved through ambiguity, refusing to let even the most well-connected litigants bend the rules. Tales in the legal community told of defense teams forced to rewrite entire strategies after a single pointed question from Judge Chutkan. In contentious cases involving politicians or hot-button issues, her iron control was the difference between chaos and clarity. I didn't smile much or make small talk during proceedings. Every moment under her gaze felt like part of a final exam. Opposite the bench sat Congresswoman Jasmine Crockett, rising star from Texas, and a paradox in power, both a disruptor and a traditionalist, as comfortable breaking down high-level legalese for the public as she was challenging authority head-on. Her background read like a boot camp for radical reform: years as a civil rights lawyer, hundreds of courtroom battles, and a reputation for championing the causes others found impossible. She was the kind of public servant who made political insiders nervous, blending deep legal knowledge with a magnetic ability to connect with ordinary people. Crockett's rise was meteoric. In Congress, she was the go-to for every fight involving rights and responsibility, her speeches equal parts law lesson and rallying cry. She tackled hard cases no one else would touch and, over time, won over both allies and skeptics with her clarity and conviction. What set her apart wasn't just her intelligence, but her knack for framing every issue as both a personal and national story. She understood the law's power because she'd wielded it on behalf of those who'd been left voiceless for too long. Their backgrounds couldn't have been more different, yet fate had placed both women at the center of this historic clash. Chutkan represented order, precedent, and the hard lines of constitutional tradition. Crockett, the possibility for change, the promise that the law must move forward with the struggles of the people. In the eyes of some, Chutkan was a bulwark against chaos, proof that the system could deliver justice without fear or favor. In the eyes of others, Crockett was a beacon for the next generation of legal warriors, refusing to let entrenched power decide whose voices would be heard. So, as they faced off, the room braced. These weren't just adversaries, they were symbols for everything that was at stake: stability versus progress, tradition against transformation. Every glance, objection, and question crackled with meaning. The battle lines were drawn, not just between two women, but between two visions for justice in America. What made the drama unfolding in courtroom 12B so electrifying wasn't just the personalities, it was the far-reaching consequences riding on every motion, every argument, every raised objection. This wasn't another routine legal contest. It was, as one commentator put it, a battle for the very DNA of American governance. At the heart of the storm was Executive Order 40823, a sweeping mandate that empowered federal agencies to override state laws under the expansive banner of national economic security. The stakes, simply put, were epic. If upheld, the executive order would blast a hole straight through decades of federalism. Environmental protections carefully built by states could be tossed aside if deemed too restrictive by a Washington bureau. Worker safety regulations, civil rights ordinances, and local business laws, all painstakingly crafted and fiercely defended, could suddenly vanish at the whim of unelected officials. The delicate balance between state autonomy and federal enforcement, a keystone of American constitutional design, risked collapsing. This wasn't a fight divided neatly along party lines or ideological camps. Unprecedented alliances formed in opposition. Republican governors and progressive activists found themselves on the same side, joined by small business leaders fearful of their local advantages evaporating, and by labor unions dreading the loss of hard-won worker protections. Even some constitutional conservatives, typically wary of government intervention, rose up, alarmed at the raw concentratis, spawn of executive power. To the public, the language of national security sounded urgent, an easy justification in a world defined by global competition and threats. But behind closed doors, legal experts warned this rationale could be weaponized to bypass Congress and silence local voices. No wonder law professors started calling the case the new Marbury vs. Madison. Legal scholars assigned it to students mid-semester, and law school halls buzzed with anxious debate. People sensed that this courtroom wasn't just settling a technical point, it was laying down a roadmap for how America would respond to future crises, economic, environmental, or civil rights. Even the business world buzzed with apprehension and intrigue. Giant corporations saw opportunity, an end to the chaos of 50 separate state rules. But the Main Street business owners and local chambers of commerce knew they could be wiped off the map overnight, unable to compete with behemoths gaming a streamlined, federalized system. Environmentalists decried a coming green rollback. Civil rights advocates feared their historic gains might be wiped away, all in the name of efficiency. Above all, there was a haunting question in every corner of the courthouse. If this executive order was held, what couldn't the government justify in the future? Could the very principle of checks and balances be swept away by convenience and crisis talk? That's why nerves frayed, cameras waited, and partisanship seemed to momentarily dissolve. What unfolded in 12B had the power to redraw how laws are made, who gets to enforce them, and whose rights would survive the politics of the next emergency. It wasn't just a trial, it was a reckoning for the American system itself, a verdict that would echo for generations. The government's legal team swept into courtroom 12B radiating assurance, their case sharpened by months of careful preparation under veteran prosecutor Michael Harrison. Harrison, a constitutional heavyweight with Supreme Court experience, took command from the moment he introduced his first exhibit. Their argument wasn't just formidable, it was airtight, at least on the surface. Harrison began by walking Judge Chutkan and the packed courtroom through the long arc of executive power in American history. From Washington's precedents through the sweeping moves of FDR, he illustrated how each crisis of governance stretched the boundaries of federal authority a bit further. The message was clear. Moments of national peril had always demanded strong, sometimes unconventional action from the president. He focused intently on the rationale for Executive Order 40823. National economic security, he argued, wasn't an abstract concept. Global threats, cyber warfare, and economic instability all required a president who could override state-by-state dysfunction for the good of the nation. By tying the issue to globalization, supply chain fragility, and rising competition from rivals abroad, Harrison invited the court to see the executive order as not only effective but essential for survival on the world stage. The legal foundation was thorough and imposing. Citing decades of precedent, particularly Supreme Court cases granting wide leeway during emergencies and for interstate commerce, Harrison contended that the Constitution gives the executive sweeping authority where state regulations might hinder the country's ability to act swiftly. Visual aids and lists of cases punctuated his every point, reinforcing the impression that the government's lawyers were not only right but had anticipated and outmaneuvered every challenge. Their case rested firmly on three pillars. First, Harrison insisted that the president's constitutional mandate to faithfully execute the law granted the necessary scope for issuing such an order. Second, he invoked national security, drawing on post-9/11 precedents to justify broad interventions as a matter of public safety and stability. Third, he painted modern commerce as a tangled web that only centralized power could untangle, warning the court of regulatory gridlock if federal agencies couldn't step in. Yet beneath the polish and confidence, a current of tension ran through the room. While Harrison's arguments were powerful, the hearing wasn't over. The air crackled with anticipation over how Congresswoman Crockett, the relentless civil rights attorney and legislator, would answer such an imposing case. Legal analysts in the gallery scribbled notes, knowing the real firework, while the government's legal team dazzled the courtroom with polished presentations and a barrage of Supreme Court citations. Congresswoman Jasmine Crockett was quietly building her own arsenal, a very different kind of preparation. She didn't have a squadron of federal lawyers at her disposal or unlimited resources. What she did have was the tenacity of a civil rights attorney who understood that the real power in any legal fight lies in what can be proven, not just in what sounds persuasive. Crockett knew her opposition would rest its case on precedent and surface-level interpretations, so she set out to dig deeper, into the forgotten corners of congressional history. For weeks, while most lawyers pored over easily accessible case law, Crockett was working late into the night, lost in the labyrinth of the National Archives. She scoured stacks of yellowed congressional transcripts that had never been digitized. She traced amendments proposed and rejected decades ago. She pored over committee reports that captured the true spirit of legislators who built our constitutional order. Her research wasn't confined to public records. Crockett reached out to retired congressional aides, combed through the personal letters of lawmakers who'd penned original statutes, and spoke with the families of legislators whose memories could shed light on old debates about executive power. Every overlooked memo, every rejected amendment became a tile in her mosaic, a portrait of a Congress far more cautious about presidential authority than the government's legal team claimed. Her findings were both a legal goldmine and a narrative weapon. She uncovered entire floor debates in which lawmakers openly warned of the risks of unchecked executive orders. She found testimony and reports showing that, time and again, Congress had purposefully rejected language that would have granted presidents sweeping unilateral control over state laws. There were even correspondence and memos from past presidents, quietly acknowledging that they, too, believed such powers required explicit congressional authorization. During the days leading up to the hearing, Crockett's team grew a folder thicker than some law school textbooks, stuffed with these historical treasures. Each document was more than an exhibit. It was ammunition in the fight to show that original intent cannot be cherry-picked to serve modern expedients. This wasn't just legal prep, it was a story, one that placed the voices of America's past directly into the heart of today's reckoning. Crockett's greatest challenge wasn't gathering evidence, but distilling decades of legislative thinking into a clear narrative powerful enough to cut through Judge Chutkan's skepticism. She knew political grandstanding would be ignored or even punished. Her approach was different: illuminate, don't inflame. By grounding her arguments in the context and emotion of the people who wrote the laws, she turned dry constitutional debates into a living, breathing story. So, as the hearing loomed, Crockett's outward calm was anchored by the confidence that she wasn't just armed with obscure facts. She had uncovered the soul of the law, and she was ready to wield it. With a single, thick folder of history and a voice sharpened by years in the trenches, she prepared not just to object, but to fundamentally transform the debate in Courtroom 12B. The sense of inevitability in Courtroom 12B was palpable, as Judge Chutkan, with her trademark steeliness, signaled that Congresswoman Jasmine Crockett's testimony might not even be needed. Legal experts and observers exchanged knowing glances. Surely the government's airtight presentation had already closed the door. But Crockett, raised on cases where determination outlasts doubt, was undeterred. Calmly she stood, her voice steady and respectful, but edged with resolve. "Your Honor, I do have something new, something I believe will fundamentally change how this court sees this case." A ripple swept through the packed gallery as Crockett laid a thick folder on the lectern, its very presence a silent rebuke to the assumption that all the facts had already been aired. "With all due respect," she continued, every syllable measured, "the government's case rests on precedent and selective readings of legislative history, but the true record tells a deeper story." She opened the folder, and from within, history began to upend the present. First, she produced original congressional records from the passage of the 1947 National Security Act, including not just the final law but the gritty details of days-long debates and amendments, specifically those which would have granted presidents broad powers like those now being claimed. She pointed to amendment after amendment, explaining how Congress had explicitly discussed and then rejected these sweeping powers, making clear that restraint, not carte blanche, was the legislative intent. The government's legal team, poised and once unflappable, began to shuffle nervously as Crockett's evidence punctured their narrative. But she wasn't finished. Out came personal correspondence between Senator Robert Taft, the amendment's author, and President Truman, letters in which Truman himself admitted that such executive authority would require additional approval from Congress. Even Judge Chutkan, who minutes ago seemed close to shutting down this new line of inquiry, leaned in, pen scribbling furiously. The crescendo arrived when Crockett introduced a never-before-reviewed DOJ memorandum, its very existence a surprise to nearly everyone in the room. The memo, just 6 months old, stated in plain language that the type of executive order under contention here would be of questionable constitutional validity without explicit congressional authorization. For a moment, time seemed to freeze. Reporters feverishly signaled their outlets. Legal scholars shook their heads in astonishment. Even the government's lead attorney paled beneath the harsh courtroom lights. Judge Chutkan, no longer composed, demanded clarification. Where did these documents come from? Why were they not included in earlier filings? Crockett smiled, the gravity of the moment written in her eyes. Your Honor, they were in the National Archives, misfiled for 70 years, only recently digitized. I worked with archivists and the families of former lawmakers to recover them, and I believe they changed the heart of this case. Silence hung for a heartbeat before the conversation erupted. This wasn't a legal tactic, it was a radical reframing. Crockett hadn't just offered evidence, she'd brought the ghosts of America's past into the present, forcing the court to reckon with what the founders had truly intended. The hearing, once almost routine, became the legal drama of the decade, and Crockett, bowed, had turned the tide. The courtroom fell into a stunned silence, the weight of Congresswoman Crockett's revelations settling like dust in the historic halls. But silence was brief, because moments later those ripples became a nationwide wave. What happened in courtroom 12B was far more than a victory for a single legal argument. It became a viral sensation, instantly captivating the public imagination and rewriting the narrative on American constitutional law. Within minutes, radio broadcasters scrambled to describe the chain reaction Crockett had set off. Social media platforms erupted. Hashtags like #CrockettConstitution and #Courtroom12B surged to the top of trending lists, rallying millions around a saga that transcended the usual partisan divides. Clips of Crockett's poised, razor-sharp testimony, her unveiling of misfiled congressional records and the DOJ memo, looped endlessly, viewed by countless Americans who just hours before had never heard her name. Commentators, legal scholars, and everyday netizens marveled at how deeply Crockett had dug and how calmly she had delivered under fire. Analysis pieces branded her performance a masterclass in constitutional advocacy. TikTok and Instagram erupted with explainer videos, some breaking down the nuances of the 1947 debates, others cheering the coolest courtroom mic drop of the year. Law students hosted virtual watch parties and annotated transcripts, while Twitter buzzed with threads that read like mini law lectures. Mainstream media outlets, sometimes known for spinning partisan divides, seemed united in awe. Networks from CNN to Fox News highlighted Crockett's evidence-based approach and clear passion for legal foundations. Even commentators from opposing sides hardened by political battle acknowledged this was history-making. Conservatives who favored strict constitutional standards praised Crockett's discipline and research regardless of party. Legal forums and news sites overflowed with deep dives. Users built infographics detailing Crockett's evidence trail, and university professors watched as sign-ups for classes on constitutional law and historical research climbed. The story became viral not only for its drama, but also for its substance, igniting a new respect for archival research and the value of congressional record-keeping. Outside legal circles, too, the impact grew. Labor unions cited the moment as a rallying point for defending state-level worker protections. Environmental advocates leaned into Crockett's precedent to defend state regulations. Grassroots organizers and civic groups saw a new opportunity. The hashtag #CrockettConstitution became not just a meme, but a banner for discussions, workshops, and deeper community engagement about checks and balances. For a time, even America's famously combative political media lowered the temperature. Crockett's example inspired calls for more reasoned, respectful debate rooted in fact and history, not rhetoric and gamesmanship. Her moment in 12B became more than a legal flashpoint. It was a rare burst of clarity. It rekindled belief in the idea that, with enough work and the right evidence, the system can respond to citizens who refuse to be silenced. Ordinary Americans, teachers, students, workers, were suddenly discussing legal doctrines, generational correspondence, and the legacy of congressional intent around their kitchen tables. This wasn't just a courtroom win, it was a seismic event, a reminder that moments of brilliance can ripple outward, rewriting what a nation believes possible in the pursuit of justice. The reverberations weren't just history, they were hope, showing how one clear and fearless voice can shift a culture and change how power works. In classrooms, courtrooms, and living rooms alike, the conversation had changed, and it was Jasmine Crockett's clarity and courage that started it. The repercussions from courtroom 12B didn't just evaporate after verdict. They spread like wildfire, reshaping America's legal, social, and political landscape for months to come. The fallout was immediate and tangible, reverberating through institutions, communities, and the very fabric of American democracy. Legally, Judge Chutkan's landmark decision, a preliminary injunction blocking Executive Order 40823, set the tone for a new era of constitutional interpretation. Her 47-page ruling cited Congresswoman Crockett's riveting evidence and the government's failure to disclose a critical DOJ memorandum, sending a clear signal. Unchecked executive power would not go unchallenged on her watch. The emphasis on congressional intent and full transparency was a direct warning to future administrations about the impermissibility of legal shortcuts. As government attorneys scrambled to regroup, their decision to appeal to the D.C. Circuit Court of Appeals was seen by legal experts as an uphill climb. Crockett's archival findings and the DOJ's own skepticism had tilted the legal landscape. Many inside legal circles whispered that this case could soon stand beside the big precedents of American constitutional law, fundamentally shifting the balance of powers. The ripple effects extended far beyond the courtroom. Socially, the case lit a spark of civic engagement rare in today's divided times. Civic organizations, grassroots groups, and advocacy networks seized on Crockett's example, hosting town halls, workshops, and campaigns to educate Americans about federalism, executive power, and the enduring importance of historical research. Universities saw a surge in students enrolling in constitutional law courses, and the National Archives reported unprecedented interest in its collections. Politically, the case was seismic. Crockett's triumph cemented her as a leading voice not just in her party, but nationwide. Her success led to increased campaign donations, endorsements from across ideological divides, and greater leverage in Capitol Hill negotiations. Governors, state houses, labor unions, and environmental groups banded together as bipartisan coalitions, newly empowered to challenge federal mandates with solid legal strategy. Media coverage kept the story alive for weeks. Op-eds, talk shows, and podcasts dissected every twist, and Crockett's poise was widely praised as a new model for principled advocacy. For once, diligence and historical depth outshone the theatrics so common in political spectacle. In Congress, the drama sparked serious reconsideration of the limits on executive orders. Lawmakers across both aisles began drafting bills to clarify and strengthen congressional oversight, intent on ensuring that future executive actions remain within constitutional boundaries. Most importantly, the case brought constitutional law out of textbooks and into daily conversation. Americans everywhere were reminded that checks and balances are not abstract. They're what protect everyday freedoms, clean air and water, fair workplaces, and state powers from the blunt force of expedience. In the end, Courtroom 12B was more than just an arena for a dramatic legal battle. It was the spark for institutional change, civic revival, and a reawakening of public faith in the power of research, readiness, and the relentless pursuit of truth. Jasmine Crockett's victory became a living blueprint for anyone determined to hold power accountable, and proof that with enough courage and preparation, a single voice can move a nation. As the echoes of Courtroom 12B faded, one truth remained crystal clear. Leadership is less about making noise and more about preparation, persist, and principle. Congresswoman Jasmine Crockett's story transformed from a legal victory into a lasting blueprint for advocacy and leadership, especially in an era defined by division and spectacle. What truly set Crockett apart was an unwavering commitment to depth. Instead of relying on surface-level sound bites or showmanship, she dove deep, painstakingly researching congressional archives, interviewing people most had forgotten, and connecting dots between distant legislative debates and today's urgent questions. Her ability to turn a stack of obscure papers into a compelling, clear narrative proved that when knowledge meets storytelling, even the most jaded audiences pay attention. When confronting a seemingly unbeatable government team with polished credentials and overwhelming resources, Crockett showed that true strength isn't measured by the size of your staff, but by the sharpness of your evidence and the steadiness of your resolve. Her calm, collected demeanor in the face of skepticism became a new standard for how to win respect, not by playing to the crowd, but by letting the facts speak loudest. Her journey wasn't just about legal maneuvering, but about resilience. She refused to accept dismissal or defeat even when the odds and the traditional rules weren't on her side. That spirit now resonates far beyond the courtroom, offering hope and guidance to activists, professionals, students, and future leaders who confront entrenched power and tough circumstances. Perhaps the most powerful lesson is in how Crockett built bridges instead of walls. By rooting her arguments in shared constitutional principles and historical context, she brought skeptics and allies together on common ground. Her advocacy reminded everyone that big fights over law and policy can be won through a shared commitment to truth, fairness, and transparency, not just ideology. Public debate, too, was elevated. Crockett proved that the path forward isn't through shouting, but through careful listening, diligent preparation, and unwavering integrity, traits that are increasingly rare and ever more vital in our fast-paced, polarized era. Her story is now taught in classrooms, debated in boardrooms, and discussed over family dinners, a paragon for how leaders really shape history, not with bravado, but with intellect, empathy, and strategic stamina. Crockett's legacy urges us not to shy away from complexity, but to dig deep and keep asking better questions. Unity and progress, she shows, are found in informed, respectful dialogue and the relentless pursuit of justice. As American politics runs ever faster and noisier, Crockett's example offers an enduring lesson. Real leadership is measured by preparation and principle, not just presence. Courtroom 12B proved that one voice grounded in truth and courage really can echo through history and spark a new era of accountability, civic engagement, and hope. That, in the end, is her greatest victory.